Okay, can everybody hear us? Just say comment by saying yes.
Hello, it's Damin Murdock here. We're still setting up. We're waiting for some people to join us, but it'd be great for you to specify what you want to hear about today. We will be starting with commercial leases. So for those who are interested in that, that will be the starting point. But please let me know what you want to talk about. There's a lot of topics. A lot of them be covered already in past webinars. So feel free to put your comment if you're watching by YouTube, so that I can see what you want me to talk about and address in this presentation. Thank you. I'll be back in 2 minutes. Welcome. Thank you for joining us today. I see that a lot of people are still interested in the JobKeeper, the actual legislation that was passed yesterday, having a look at the new commercial lease changes, and having a look at the award changes and Fair Work Act. So all of those are going to be discussed today. Now, just by way of background, this is our third webinar over a series of 3 weeks. The first webinar, which was on the 1st of April, I believe, it deals mostly with employment law redundancies, standing people down, and it goes into Australian consumer law as well, such as if you're breaching your duties as a seller of product or services. And then our next webinar, we primarily dealt with occupational health and safety and the JobKeeper payment. That webinar went on for about 2 hours, and we had almost 95% of our viewers stayed in to listen to the entire webinar. So thank you very much if that was you. And we had about 300 questions, and we went through each one of them for about 40 minutes. And today we'll be trying to go through all your questions as well at the end of this webinar. But today it's not going to be 2 hours. It's going to be much shorter. And we're going to focus on the new developments first. We'll then touch upon some of the items that we discussed in the past webinars. But if you want more information on those, watch those past webinars. So to begin with, my name is Damin Murdock. I'm a principal lawyer from Murdock Chang Legal Practice. I've been practicing law for many years. I'm admitted in Queensland, Victoria, New South Wales, and we have an office in Victoria and New South Wales. As I mentioned, we're going to focus on commercial leases at the beginning. We're going to get into the changes to the Fair Work Act and the awards. Then we're going to get into the JobKeeper and some of the other elements that we dealt with in the past webinars quickly, and then get into some questions, because I think there's a lot of people that are confused. There's a lot of unknowns still, not just you, but myself as well. And we are still waiting to find out all the particulars. But we have a lot more information because Parliament sat yesterday, the bills were passed, and we're pretty much the first ones to present on these new issues. I just finished my slides about 10 minutes ago after reading up on everything last night and most of today. So if there are typos, I apologize. Yes, this is recorded. Yes, it can be streamed online later at your leisure. You can fast forward and rewind to deal with the different topics that you might be interested in. Before we start, obviously, this is general advice, not specific. There is a lot of specifics that people need. I will try to answer most of those at the end in the Q&A session. So let's talk about the National Cabinet Mandatory Code of Conduct. This is dealing with commercial leases. For the next 10 minutes or so, I will be dealing just with commercial leases, and then we'll be getting in to the changes to the Fair Work Act, and then we'll be getting into the JobKeeper. So the National Cabinet Mandatory Code of Conduct was released by the PM, by the Prime Minister, and it basically sets down a mandatory code which must be enacted into law by each state and territory. That means each state and territory might have slightly different legislation, which will be passed. However, the mandatory code sets the ground or the bare minimum of what's required to be put into this legislation. So the high level purpose of the code, which can be found at the website that I've given you, or you can get access to the digital copy of these slides so that that link will work when you actually click on it rather than when you're streaming it. So high level, the purpose of this code is good faith leasing principles for retail, office, and industrial sites. This is commercial leases, and it only applies to companies who are eligible for the JobKeeper payments. What you'll see is almost all of the changes that have happened are directly and correlated directly to the JobKeeper payments. So if you want to look at the award changes, normally those only apply to those who are eligible for the JobKeeper payments. If you look at the Fair Work Act changes, normally that's only going to apply to those who are eligible for the JobKeeper payments. If you look at the mandatory code for commercial leases, same thing is going to be there. So if you're not eligible for the JobKeeper payments, there is a possibility that you may not be eligible to the benefits that I'm going to be talking to you today. Having said that, the JobKeeper payments are very flexible. And because they're very flexible, most companies are actually going to be eligible, or most companies who have seen a downturn will be eligible. The next thing is looking at this code. It's during the pandemic period only, as announced by the Australian government. We are in the pandemic period right now, and it's continuing until the government says we're not. And it will be passed by legislation, but has not been passed at the moment. But it does not mean you cannot start implementing these procedures right away. So what does the overarching principles deal with? It's passing on whatever the landlord gets from way of benefit to pass that on to the tenant. I alluded to this in my last webinar because as a lawyer, most of it's by way of analogy. Laws are by way of analogy. And I predicted that this is pretty much what they're going to be saying is if the landlord benefits, they should be passing that onto the tenant proportionately. And this is what the overarching principle is that there's going to be a proportionate share, in a measured manner, and for the pandemic period. But they are not able to pass a law that is strict and clear that anyone can just simply follow. It's not, you're automatically entitled to 50% deduction of the rent. That's not, they can't implement that because every situation is different. So instead, they've implemented a mandatory code that must be followed, and then they'll be passing legislation, most likely saying you must comply with the code. So let's look at this. It's looking at working together, ensuring that there's a continuing lease after this pandemic. It's making sure that when the pandemic ends, people can jump straight back into their business and keep on going as if nothing had happened. It's forcing discussion between the landlord and the tenant and forcing a good faith discussion to happen. It requires open honesty and transparency. And I have talked to a lot of people that actually haven't been suffering that much from the pandemic, but they're still trying to get commercial lease reductions. Unfortunately, that might not fly. And the reason is you're probably going to have to prove with evidence that there actually is a reduction in your turnover and a downfall in your business to be eligible to negotiate your commercial lease reductions. So they're going to look at your revenue, your expenses, your profitability, and they're going to come up with something that's fair between you and your landlord. And they're going to pass on any benefits they get from the government or utility companies and so on. There are several different principles, and they are as follows. Number one, they must not terminate the lease because of non-payment. That sounds fantastic, and a lot of people says, oh, well, now I don't have to pay. But that's not true either. You are still required to comply with your lease obligations, but you have to negotiate with your landlord if you want a reduction. Simply not paying is not an answer, and there will be an opportunity for that landlord to recoup any loss and damage suffered as a result of you not abiding by the terms and conditions of your lease. Also, this code of conduct does not apply to a tenant that simply does not abide by the terms and conditions of the lease. So if you think you can just stop paying, you're wrong. You're not going to get any benefit at all if you just simply not pay. You have to negotiate. That's step one. Number two is you have to be committed to the lease and subject to any amendments that are entered into. But as I mentioned, if you do not comply with the lease, you're going to forfeit your protections. That's number two. Number three, the landlord must offer tenants proportionate reductions in rent in the form of waivers and deferrals. And that must be a reduction based on the tenant's reduction in turnover. But when you have a look at that, it also deals with, if you look at number 4, if you get a waiver or a deduction, it won't just simply be, I've reduced my turnover by 50%, and therefore I get a 50% reduction in my lease. What the principles say is that if you've got a reduction in your turnover by 50%, you may be able to get your lease reduced by 25% and during the pandemic period. And the other 25% you can pay at a later date once the pandemic is over and everything's back to normal. So you split between a waiver and a deferral. And it's half waiver, half deferral. Again, it is negotiable, but these are what the principles are all about. And so point 4 deals with the 50-50 split between waivers, and deferrals. Now, if you're going to get a deferred payment, so the waiver is reduction of rent, deferred payment means I have to pay later. If you reach an agreement where you're going to reduce your rent, but the other portion will simply be deferred later, then that deferral is not due immediately upon the pandemic ending. That amount that is accrued during the pandemic will then be a lump sum at the end of the pandemic, and it has to be amortized over 24 months. So it will be an installment payment over a 24-month period, or over whatever amount is left over in the lease. And this is why the government's had troubles legislating, because some people's commercial lease might have ended last week, and now they're on a holdover period. And so every circumstance is different. Some people don't have 24 months left in their lease. Some people only have 4 months left. So it's going to come down to negotiating. But if you look at these principles, this is the guideline on how you're going to negotiate. Principle 6 is that if the landlord receives a statutory reduction, such as council rates or land tax, they must pass on that proportion over to the tenant. Principle 7, if the financier gives them a benefit, then they must pass that benefit on to you. Now, let's think about that for a minute. What does that mean? If a landlord has a $3,000 mortgage during or while you're a tenant, and that mortgage payment of $3,000 a month is 100% interest payment, so it's actually not paying down the principal, and the financier has stopped all interest payments, then that essentially means that that landlord should be passing on an opportunity for you to reduce your rent by $3,000, because they're not having to pay their interest payments, and therefore they should be in a position where they can reduce that benefit or pass that benefit on to you. Number 8 is a landlord should seek a waiver for outgoings from their strata. Obviously, the cost of buildings is not the same cost as what it is when the elevator is going up and down every day and every 5 minutes. The electricity costs and everything else are now reduced, which means the landlords have an obligation to go to their strata, if it is a strata property, and say, you know that the outgoings are being reduced. You keep your finger on the pulse. You tell us how much our overheads are being reduced, and you tell us how much that is. And once we know, we will also in turn pass that on to the tenant. So it puts an obligation on the landlord to make sure that they're on top of everything, and they're asking for deferrals and discounts as well to not only their financier, but also to the strata and any other utility companies. Now, number 9 is if there is an agreement made and there is a requirement for repayments repaid at a later date because of a deferral, that should be over an extended period of time that's not going to put an undue financial burden on the tenant. So the first payment should not be the immediately after the pandemic ends. It should be after some time back in trading, 3 months, 6 months, whatever it might be. But what it should not be is right when you're back into your office, now I have to pay. Because that's undue burden. You have a transition period to get back up and running. And they are not allowed to charge you any kind of penalty or interest or charges as a result of you not paying your deferred amount until a later date. So it's an interest-free deferral. Landlords are also prohibited from cashing in on your bond or bank guarantee or personal guarantee right now during the period. So if you receive a threat from the landlord that says, if you do not pay your rent, then I'm going to call in on your security, or I'm going to call in because you have given me a personal guarantee, they're prohibited from doing that. They should not be doing it. And when the legislation comes in, I'm quite certain that the legislation will stipulate that. Right now, it's a code to be followed. It's not legislation. But if they try to do that, you most likely be able to run up to QCAT, NCAT, VCAT, or one of the tribunals in your relevant jurisdiction to stop that from happening. So if you get that threat, you can stop them from actually enacting it or doing it by either calling up a lawyer, telling them to stop. You can call myself as well. You can call LawPath, or you can file a claim in the relevant tribunal that has jurisdictions, or your local small business commissioner. They also say that landlords should be having flexibility in the term of the lease. If you have a lease that's about to expire, they're saying to landlords, extend it. This is all common sense. The reality is as a tenant and a landlord, you have to work together. And the reason you have to work together is because if the landlord tries to kick out a tenant now, well, there's no one that's going to be moving in there for quite some time. So it doesn't make a lot of sense for a landlord to now kick a tenant out of the property, because it's going to remain vacant probably for 12 months, depending on whatever city you're in. But even after the pandemic is over, they're probably not going to be able to find a tenant very quickly. There's also normally a rent-free period or a fit-out contribution, which extends further for another period of time. So they're saying, landlords, use common sense, negotiate a tenant. It's in everybody's interest to keep them in there. Extend your lease if you have to, and discuss in good faith between the parties. Some retail leases say that a store must operate from 9 to 5:30, or they must operate during the shopping center hours. And if they don't, they can send a default notice to that retail outlet saying they're in breach of the lease. And if they don't rectify, then they can terminate the lease. This code says a landlord's prohibited from issuing a default notice to a retail outlet for not operating during the normal course of hours, which their lease says they're required to do so. So it now gives retail outlets, mostly retail outlets, the opportunity to choose their own hours, close down early if they want to, not open at all if they want to. And there should be, again, a passing of the benefit. If they get a benefit from the financier, that benefit should be passed on to the tenant. And then they're putting in a legally binding mediation, which is the landlord will be prohibited from going straight to court without first referring the matter to mediation and trying to get a third-party mediator from the local small business commissioner to negotiate an outcome. But what a landlord should not be doing is simply not agreeing simply because they don't want to agree and don't want to offer anything, refer it to mediation and wait till the mediation's held, and then go to court after that or to a tribunal after that, simply to defer reaching an agreement. If they were to do that, there could be issues with the Competition and Consumer Act. There could be unjust terms in the contract. There could be certain penalties that apply if you're specifically using a mediation clause to purposefully delay in bad faith. Now, what if you are not eligible for the JobKeeper payment as an employer? There's other things to look at. You, as a tenant, have the right to acquire an enjoyment of the land that you have rented. You have the right to your amenities. And if you cannot get access to your building, and if you do not have the amenities that have been offered to you, there is a possibility for you to go and make an application for a rental abatement. And you can go to QCAT, NCAT, VCAT, or the relevant tribunal to seek an order for a rent abatement. A rent abatement means a reduction in rent. However, with the code applies to those who are eligible for JobKeeper payments. So if you don't or not eligible for JobKeeper payments, then your only option might be going and making an application for a rental abatement. But if you just simply say, I'm not paying, then one, you're not going to be getting the benefits that are in the code, and two, you're not going to get much outcome from the tribunals if you just simply don't pay. You have to consider what portion of that property am I not benefiting from? Is it 100%? Is it 20%? Is it 10%? Is it 5%? The same thing will apply with commercial leases or residential leases as well. There is an opportunity for rental abatement potentially. So if you have a swimming pool and gym and you've been using the swimming pool and gym in your complex every single day, and the reason you rented that property was to not pay for a gym membership and not pay for a pool membership, and now you don't have access to that, then there might be a possibility that you can get a rental abatement from a rental tenancy perspective. Now let's look at Fair Work Act, the amendments in the bill that was passed yesterday evening. So what has happened? What are the changes? Essentially, what has happened with this new bill is that they're inserting new clauses into the Fair Work Act. And it's going to be part 6 to 4C in section 289 GB and some other sections around there that deal with this. Now, the Fair Work Commission has been very quick in their actions, and the bill passed. The Fair Work Commission exercised the powers that were granted to them, and they immediately varied 99 modern awards overnight. And what that means is that they've actually automatically changed what those awards say. And I can give you an example of what the changes were to the Hospitality Industry Award to give you an idea. And most of the awards are universal across the board. But first, let's look at the 4 main changes. The first one is all employees are entitled to take 2 weeks unpaid leave if they're required to isolate. So you're not allowed to terminate their employer or their employment because they have been absent for 2 weeks, but the employee needs to give notice and they have to prove with evidence that they need to isolate. And that evidence is evidence from a government initiative, such as they've just come in from overseas. Clearly, they have to isolate. They're locked up in a hotel. Number 2, they've traveled interstate. Possibly there's a requirement there. 3, they may have a family member come in contact with someone. They might have come off a cruise ship, whatever it might be. If they have that requirement to isolate, then they are allowed to have unpaid leave, not paid leave, unpaid leave for 2 weeks. You then look at annual leave. The employee is allowed to use up their annual leave, but double the duration of those entitlements. So they can take half pay, so it's staggered out. So if someone makes $1,000 a week, has 2 weeks of accrued leave, they can extend that out to 4 weeks and get it paid incrementally over those 4 weeks. This is what most people are interested in. The Fair Work Act and the Modern Awards has allowed for the reduction of hours. So a full-time employee is allowed to be reduced down from 38 hours to 22.8 hours. And a part-time worker is allowed to be reduced down to 60% hours. And these are in circumstances when they are still able to do work. You can also force annual leave. And by forcing annual leave, you have to give 24 hours notice. But people will be saying now, well, I don't need my full-time employee on 22.8 hours, and I don't need my part-time worker on 60% of what they were doing. That's because I don't need them at all. And if you don't need them at all, then you are allowed to stand them down completely. But you have to remember, these provisions are connected to the JobKeeper payments. So you cannot just simply go and stand someone down if you have not seen a downfall or reduction in your turnover. That is something that's really misunderstood. You have to be eligible for the JobKeeper payments to be able to get these benefits. And if you can't just randomly stand down whoever you feel like it, simply because you feel that you don't need them anymore. What you would need to actually do is that if you do not, or if you're not eligible for the JobKeeper payments, then what you need to do is you need to consider potentially forced annual leave, which you can do under Section 94 of the Fair Work Act, subsection 5, or potentially consider redundancy. But going back to redundancy, this is not what the intention of the government is. The government is saying, we want as many people possible to be eligible for the JobKeeper payment, and for them to be, and then once they are eligible, we will allow them to stand them down to zero pay because they're not working in our business. However, we want them to pay the $1,500 a fortnight, and we will subsidize that 100% so that the employer is not out of pocket. But at the end of this pandemic, you still have your employee. You haven't had to pay them anything. The government has kept them on the books for you. You then are back up and operating just as things were overnight, back to business. And it's a very quick bounce in the economy the minute this pandemic ends. So let's get into the JobKeeper payment. As I mentioned, the last webinar, we went into this at length. Our webinar was 2 hours and 40 minutes of questions specifically on this. So I'm not sure how many people heard the last presentation and webinar and went through those questions, but I'm not going to get into the length and the depth that I did on the last occasion, but we will touch upon it quickly. So the common questions. Stand downs should only apply if there are changes which you can attribute to COVID-19. This is a real requirement of a reduction of hours. If you cannot prove that your employee is no longer required, then you are falling foul to the Fair Work Act. You have constructively dismissed your employee by changing the terms and conditions of your employee's employment rights and contractual obligations unilaterally without a legal right to do so. And by doing that, you could open yourself up to an unfair dismissal claim. So you have to be very careful. And what the government is reiterating is that this has to be proven and attributable to COVID-19, and it can't be a farce or sham to just try to sack people. Employers must act reasonably and prove and have the evidence to show that what they're doing can be backed up with evidence. And you can only stand down your employees generally if you're a JobKeeper payment eligible employer. And you still need to comply with the Fair Work Act and the Modern Award. And I'll get into your main obligations contained in those acts if you're not a JobKeeper payment eligible employer. So let's just get into the JobKeeper payment, how it works. Many of you already know probably how it works. It's been around for about 7 days. You've probably seen a webinar. You might have read up a little bit of it on it, but let's just do a quick review so that everybody's on the same page. Step one, you have to be an eligible employer. An eligible employer, I'm only dealing with those that make less than 1 billion. There are other rules for those that make more than 1 billion, but that's not our target audience. So those who make less than 1 billion, their turnover has fallen by more than 30% when comparing it to a typical month in the last 12 months. It does not mean comparing March 2020 to March 2019. It means having a look at it from a high-level general perspective, looking at whether your turnover is reduced by 30% on average, whether the COVID-19 situation has actually just had a significant effect on your business. There's going to be consideration given by the ATO in determining this. There's going to be flexibility, and they just want to make sure that all the employers are using good faith. I can see a lot of the questions have stopped coming up. Keep them coming if you want, because I have plenty of time to go over those questions. And then also have a look at the economic downturn and whether it might not affect you now, but you know, and you can prove with evidence it's going to. In that scenario, you're likely eligible for the JobKeeper payment. Number two, once you're eligible for the JobKeeper payment, you then have to look at whether your employee is eligible for the JobKeeper payment. So an employee who is eligible were they on your books on the 1st of March? It doesn't matter if they've subsequently been terminated. It doesn't matter if they're subsequently made redundant. It doesn't matter whether you stood them down. As long as they're on the books, you can then rehire them before the 30th, before the end of this month. You can rehire them and you can make the payment to them, and they will be deemed an eligible employee. It does not apply to casual employees unless that casual employee has been working in the business for a period of 12 months on a regular and systematic basis. I've got a lot of questions about this, so let me just try to recall those questions and go over them quickly. Does it apply to a director that's taking a director fee? Most likely not. It applies to employees. If you're a director of a company, a startup, and have never recorded yourself as an employee on the books and withheld tax to your wage before the 1st of March, you're probably not eligible, because you have to remember, the person that's assessing this is a person who is in the ATO. When assessing it, the ATO is looking at your records and whether you have applied pay-as-you-go withdrawals previously. If you were not an employee on your books and withheld tax to your salary, then you don't qualify. You don't meet the bare minimum requirements of what they set out. Now again, although the bill's passed, I'm still waiting for the act to now come into effect. So there still could be a situation where they do extend that, but as far as I can see, that's not extended. Doesn't mean that you're not going to be eligible to the job seeker payment. Your startup, a job seeker payment, which I'll get into, is where your wage is now less than $1,086 as a result of this. You can now go and get a Centrelink payment. But if you're not an employee, as at the 1st of March, on the books, recorded with the ATO, then you're not likely eligible employee. The other one people have asked is, what about a casual? We've restructured our business. We had a subsidiary that was hiring a casual, and then we opened up a holding company. We've transferred the employees from one entity owned by us to another entity owned by us. That's a restructuring. They're probably what's defined as a transfer employee. And as long as you didn't pay out all the wages or all the entitlements and terminate their employment and then rehire them through another entity, starting afresh with new contracts after you paid out all their entitlements, then they're likely to be a transfer employee, and the 12 months will likely continue on from even if your entity is switched. It does not apply to 457, 482 visa holders, such as temporary visas, sponsored visa holders. It applies to Kiwis, or maybe more legalese or more proper New Zealanders or New Zealand citizens on a 444 visa, and special category visa holders. It does not apply to temporary visa holders. If you look at students, uni students, they were normally only permitted to work 20 hours per week during their university subjects. And then normally it was unlimited hours when they're out of session. But even now, even if they're in session, they're, oh, I better update my, there you go. Then even now, they are allowed to increase their hours to 40 hours a week, but they're not entitled to the JobKeeper payments. So that's high level JobKeeper payments for companies, but it also, you have to look at an ABN. There are situations where you might be a director of a startup, but you might be a casual employee or an ABN holder of another business where you're offering consulting. If that's the case, you might be able to put a JobKeeper payment through an ABN that you hold. Step 3, how do you apply? Over 300,000 companies have already applied. You first make your application, you then do a self-assessment. You go to the ATO link. We recommend everybody just to make the application. You can withdraw the application later if you want, but you want to make your application, then you have to consider whether you believe you're going to be eligible to the $1,500. And so what you need to do is, to be eligible to the JobKeeper payment, is you got to pay the employee the $1,500 before tax, and you don't have to pay super on that amount. Now let me be very, very careful here, and let you be very careful on the super aspect. If you have an employee who is working normally on $3,000 a fortnight, and you reduce their hours from 40 hours to 20 hours, it means that their normal wage is now $1,500 a fortnight, and you have to pay super on that $1,500, and you'll get $1,500 back from the government. If you have an employee who is normally on $3,000 a fortnight, and you reduce their hours by to 4 days a week, which I believe would mean that they're on now a I can't remember the percentages, but if you now reduce them down to a $2,000 per fortnight pay, then you still have to, but you only need them, and you still need them for the $2,000 worth of time, you still have to pay super on that. But if you reduce their time down to 0 and you pay them the $1,500, you don't have to pay super on that $1,500. So if it's actually a wage for them doing services, you have to pay the super. But if they're actually not doing the services, you don't have to do the seminar. This webinar is going to be finishing up in about 15 minutes for that question that just popped up on YouTube. So how does it work? Quick example. I've just went through the previous examples. These are different examples. If you have an employee who's on a $3,000 a fortnight roll, and you pay that, ATO will give you $1,500 back as a subsidy. And if you have an employee that only normally gets paid $1,000 a fortnight, you still have to pay $1,500 to get the JobKeeper payment. So you actually have to top them up $500 more than what they were getting before, but you don't have to pay super on that. There was a lot of debate regarding this. There are some casuals who are only working $200 a fortnight. They still are eligible for the $1,500. They're getting a great bonus. This is because the government felt that everybody needs a minimum standard, a minimum rate. We got to keep people in their homes. We got to keep them paying their residential tenancies. So we made it across the board, $1,500 for everybody, whether they are working that amount, whether they're not working amount, $1,500 across the board. Keep it easy. Job seeker payments. You have to be over 22. If you're not eligible for JobKeeper, then you probably can apply for job seeker. If an employee of yours was made redundant or stood down and went and applied for the job seeker payment, for them to get the JobKeeper payment, they must notify the relevant department to stop their job seeker payment. They can't double dip and get both. Now, what if you are not eligible for JobKeeper? What happens if the Fair Work Act the changes don't apply to you, because most of the changes are being connected to JobKeeper scenarios? Then what else can you do? If your business is still rocking and rolling and you're still doing well and you haven't gone down by 30%, however, there's certain roles that are clearly redundant now. People going door to door, salespeople. You might have software developers who are still required, but you might need people on the phone doing sales who aren't. You might have to make a difficult decision. You might have to stand some people down and others not. Now, if you're going to stand people down and you can't show that you're a JobKeeper eligible employer, it probably means that you need to make them redundant unless they agree to other arrangement. And that other arrangement can be allowing them to take their annual leave for a period of time and putting that in writing and agreeing to it, making sure that you consult with them. If they have excessive leave, giving them the opportunity to take that leave as well. But everything must be in writing, and you have to put that into an agreement. Because if it's not in an agreement, the employee could say later that they were forced to do that, and it could open yourself up to falling foul to the Fair Work Act and the specific requirements that are specified in the legislation regarding changing or forcing annual leave to be taken. Now, what if someone doesn't have enough annual leave? Or what happens if someone is sick? Obviously, at the beginning, a lot of people saying, can I terminate someone because they're in isolation? The answer is no, you can't. You'll have to put them on unpaid leave for a period of time. And unless they're sick for 3 months, you're unlikely being unable to terminate them. Working from home policies, we've got into that twice in the last 2 webinars. LawPath has a working from home policy. If you haven't already implemented it, I stress how important it is for OH&S purposes, for insurance liability purposes to implement it. You can grab it for free off the Fair Work website. Now let's look at redundancies. There are a lot of employers out there that saying, oh, this is the perfect time for me to sack that person that I've wanted to do so for so long and I haven't had that chance to do it. I'm going to use this opportunity to make this person redundant. And then I'll just go and say he or she's redundant and I'm not going to fall foul of the Fair Work Act. Well, unfortunately, that's not right. You will fall foul of the Fair Work Act. If you're going to be making redundancies, or if you are going to be terminating someone during their probation, just like you normally would outside of this pandemic period, or if they're not fit for your organization or something along those lines, you got to be careful that you are not unfairly dismissing them and have an unfair dismissal claim pop up. So you have to take the normal measures that you would normally take before dismissing an employee. You have to take the normal measures that you would normally take before you make someone redundant. And if you're not eligible for JobKeeper payments, but there has been a fall down or a reduction in your turnover, and you might not need a certain position, as an employer, you have to look and see if you can redeploy them into another role before you make someone redundant. So you might say, oh, well, this salesperson was 9 to 5, Monday to Friday. They were attending your regular meetings. Those meetings were taking about 2 days a week. I don't need them 5 days anymore, but now I need them 3 days. What that means is that 5-day role is redundant. That 5-day role is no longer required. But now you have a new role in your organization. And that new job is a 3-day job. So you no longer need the 5-day. You make the employee redundant, saying, I'm sorry, there has been a requirement for us to change our organizational structure. There has been a requirement to make this 5-day position redundant. However, there is a role which is identical almost to your current role, which is 3 days a week, and we offer you to redeploy you into that 3-day position if you accept it. And if you don't, well, we have no other option but to terminate your employment. If you go through the proper steps in redundancy, which is consultation, looking for redeployment, having a reasonable and legitimate reason for that role to be made redundant, then you can proceed with the redundancy. But I would say that there does not seem to be any reason for any company at the moment who is receiving or eligible to receive JobKeeper payments to make a person redundant, because they don't have to pay anything to keep that person if they reduce them down to the $1,500 and pay them the $1,500. If a common question about a week ago, I got a lot of these questions, is what happens if my employee just simply refuses to come to work? An employee has to have a legitimate reason not to come to work. I dealt with OH&S requirements in the last presentation, but there's an obligation on the employer to have a safe working environment. If they have hand sanitizer, if they have an office that's clean, if they're all 1.5 meters away from each other, if there's less than one person within every 4 square meters, if you followed all the applicable laws to have a safe working environment, you need the employee to come into your workplace, then in that scenario, I can't understand a situation where the employee simply refuses to come in. And if they simply refuse to come in, then you may have to get a lawyer to go through the proper measures to issue notices for breach of their employment contract, possibly suspend them and do an investigation. But if they don't have a legitimate reason to come in, there is a possibility to dismiss them on grounds of not complying with their employment obligations. Now, as I mentioned, we've done past webinars on health and safety, Australian consumer law, managing your cash flow, collecting debts, changes to Corporations Act, employment law, a lot more detail into employment law, cash flow assistance, $100,000 to companies who have withdrawn or deducted pay-as-you-go entitlements up to $100,000, instant write-offs on assets of $150,000, government offering guarantees on $250,000 loans. You can see on the past 2 webinars more information on that, or just simply go to LawPath's COVID-19 resources page for more information. Now, let's get into the questions. and there are plenty of them. So Melissa says, I'm interested to know if JobKeeper payments include director drawings. Also interested to know about commercial leases and how to negotiate with an unreasonable landlord. So question one, I don't believe that JobKeeper applies to director drawings. If someone can direct me otherwise, then please do so. But if you're not recorded as an employee and you've been paying yourself a wage and you've been deducting pay-as-you-go from that wage, you're not defined as an employee, and I don't believe that you'll be entitled to JobKeeper payments. And in terms of negotiating with an unreasonable landlord, I suggest you give them a copy of the code. You tell them if they don't comply with that code, then you're going to refer them to the small business commissioner and force them into a day of mediation as a result of them acting unreasonably. Next question is from Kate. I'm interested to know anything to do with JobKeeper and sole traders. So JobKeeper does not just apply to companies, it also applies to sole traders, and sole traders can apply themselves directly as long as they were, essentially their own employee. As long as they were paying tax as of the 1st of March and their turnover has reduced by 30%. The only difference for sole traders is that there's an extra step, and I believe there's a statutory declaration that has to be signed off showing evidence that there's actually been that reduction. Whereas with a company, it is it's self-assessment. Next question is commercial leases and if we can cancel them without claiming bankruptcy. Well, it's two questions. The first one is, can you cancel them? The answer is no. A commercial lease just simply cannot be canceled. The code is pretty clear. You have an obligation to comply with your terms and conditions of your commercial lease, and you have an obligation to go to your landlord and try to negotiate a deal. If you simply cancel them and just simply say, I'm not paying you anything else and I'm out of here, then the code is not going to apply to you because you forfeited your rights under the code, and therefore you've just lost all the benefits that you were entitled to. But let's say a lot of small businesses have personal guarantees attached to those commercial leases. So it's not just simply saying, I'm going to fold my company, put it in liquidation, close it down, because you have a personal guarantee attached to that. So it's not that easy for you. What that means is you have to start negotiating, and you have to start negotiating quickly, and you have to give that code to your landlord and say, I'm in desperate times, and desperate times is desperate measures, and I need urgent action to be taken immediately to find out what you're going to do. And if they do not agree to reduce, defer, provide waivers, then you need to immediately jump on the small business commissioner's pages, depending on what state you're in, and get it straight to a mediation, because as time accrues, your personal liability is accruing. Having said that, the landlord cannot claim against your personal guarantee. They cannot take from you your bond during this pandemic. But remember, that only applies in a situation where you have not forfeited your rights under the code. So if you've just gone to your landlord and says, I'm terminating a lease, see you later, then you're not going to get that benefit, and they can just simply go and enforce under the personal guarantee and enforce under the bond that you've given. So it's really important to comply with the obligations of the code, and not to take any drastic measures without trying to negotiate that. Now, bankruptcy, the laws have changed slightly about bankruptcy. And we do talk about that in our previous slide briefly. Yes, Smart Property Advisor says there's too many legal challenges to keep abreast of. I agree. I stayed up very late last night and I've rushed to prepare these slides, so I certainly agree that there is a lot to stay on top of. So Amanda says, JobKeeper, 30% reduction in revenue. What period is that calculated on? I mentioned before that that's looking at the past 12 months. It's very flexible. It's not year-on-year comparison from March last year to March this year. It doesn't mean that you need to be trading for the last 12 months. It's looking at, has there been a reduction, and can you clearly attribute that reduction to COVID-19? Julie says, do we need to start paying people now? How does business get the cash to pay 6 fortnights worth of payments before being reimbursed? That's an excellent question, and I don't have an answer for you regarding that. The JobKeeper payment essentially works on the basis that you have the money to pay that upfront now and get reimbursed in probably the first week of May. If you don't have that money to do it, then the reality is you can't make that payment and you're not going to be eligible to the JobKeeper payment. So what do you do? It is a no-brainer for anyone that wants to lend money to your company on a short-term basis, or they can lend you that money for you to make the JobKeeper payment and then get the money back immediately once the JobKeeper payment comes in from the ATO. And you can consider, if you want to keep your staff, to get that quick short-term loan just for this month, or recurring months or recurring fortnights just to make that payment. But if you can't, then the reality is you're not eligible, and you may have to make your staff redundant, or call me and we can work through it, because there's a lot of people in that situation, but it's case-by-case basis. Have a question here from Rachel. If an employee is stood down and eligible for the JobKeeper payment, are they eligible to top up their payment by using leave entitlements? I had a long question with a client of mine last night regarding this. I was trying to get this question answered by looking at legislation, and I can't answer that question at the moment. I think from an analogy perspective, the answer would be no. But then from another perspective, I would say yes. I don't think the ATO are actually going to look into this that deeply. So I would think that if you are paying an employee $1,000 a fortnight, they have been stood down, they have annual leave, and you don't have the extra $500 to top up that pay to get the JobKeeper payment, I don't think you're going to fall foul to this by allowing the employee to use their annual leave to do that top up. But you have to be very careful, and I'm not going to give a definitive answer in this presentation because I'm still trying to get a definitive answer, which has not been answered. And when I do, I will try to answer it in the next webinar, or possibly get an article published by my firm or LawPath answering that question. But I cannot give you a definitive answer on that. I have a question here from Tony. Why not more than one partner in a partnership entitled? Or when more than one rely on business performance? Not fair. Well, thank you, Tony. That is a comment, but I think it actually just goes back to the foundation of the legal structure of how it is. Labor fought very hard in Parliament trying to get the JobKeeper payments extended. They weren't successful. Maybe that's one of the things that they had discussed in one of the reading speeches or one of the presentations, but I didn't go through all of them. But yes, that's correct. Melissa, eligibility. Is the 30% downturn for a selected period or period that's